Across Europe, something important is changing. For many years, statelessness was treated almost as an invisible problem, a bureaucratic anomaly hidden inside immigration files, civil registries, and cross border family disputes. But today, European institutions are slowly beginning to recognize something much deeper. Statelessness is not only an immigration issue, it is also a child rights issue, a family law issue, a civil status issue, and ultimately a question of human identity. This shift is extremely important. Recent European discussions, NGO reports, and EU procedural reforms increasingly focus on identifying and recording statelessness and nationality uncertainty earlier than before. And that may sound technical, but in reality, it affects real children and real families, especially children born into cross border situations, children of separated parents, children caught between different legal systems, children whose documents are disputed, or children who are told that another country should recognize them, while in practice no country fully does. And this is where the real legal problem begins. Because a nationality that exists only in theory is not always an effective nationality in reality. A child may formally appear to have access to citizenship somewhere, but still remain undocumented, unregistered, unable to obtain a passport, or trapped between conflicting administrative systems. Europe is finally becoming better at identifying these situations, but recognition alone is not enough. And this is the central argument of my new article. The European legal system is improving its ability to see statelessness, but it still struggles to resolve it. Many authorities can now identify possible statelessness, undetermined nationality, or documentation problems. But after identification comes the real question: what remedy exists? What happens to the child afterward? Who takes responsibility? And this is where Europe still faces serious structural gaps. The article also examines why comparative law is becoming increasingly important. Modern statelessness problems rarely belong to only one legal system. They emerge precisely because different countries recognize parentage differently, apply nationality laws differently, or allocate legal competence differently. And this creates situations where children can fall directly between legal frameworks. The article therefore argues that Europe's next step cannot simply be better registration. The next step must be effective determination procedures, child-sensitive legal safeguards, and mechanisms capable of resolving exceptional legal deadlocks. Because a child should not spend an entire childhood trapped between legal systems that each insist the responsibility belongs somewhere else. If you are interested in human rights, family law, European law, comparative law, or the future development of statelessness protection in Europe, I believe this article will interest you. For more information, read the full article on the link in the description. Thank you for watching.